Hey, podcast peeps, just a heads up, we did want to take a second and include a trigger warning. This episode will discuss topics that do touch on sexual violence. We care about you and wanted to flag this for you. If you need to skip or pause at any point, please do. As always, take care of yourselves and reach out to someone you trust if this stirs something in you. We'll be here if you ever want to come back. Welcome to Drinks with Defenders. I'm Addie B. Plate.
And I'm Kayla Murphy. We're two law school friends turned criminal defense attorneys turned podcast hosts.
We're here in this space because we now work in separate offices and miss collaborating with each other.
We've been talking about creating a podcast for years where we talk about the complexities of the criminal justice system, the aspects of it that we grapple with, and the importance of what we do.
At the end of a long work week, we want to sit down, have a drink with each other, and talk about the rabbit holes of criminal defense, just like we always have. So let's get into it. Cheers!
I mean, what is everybody drinking tonight? Addie, you showed us that you were able to get a cocktail to go. Was that like Applebee? What was that?
No, dude, I'm not gonna name blast the establishment on this podcast because I was very surprised by this move. But let me tell you, so I moved
questionable.
So I moved house, right? And I was like, okay, like let's check out places kind of in our neighborhood-ish. So we found this Mexican restaurant, which for me is a staple in any community that I live in. There has to be good Mexican food nearby. It's like comfort food for me. So we went, and if there's something about me, I love a spicy margarita. Like if something has jalapeno in it, I'm probably down to drink it. So we go, and there's a $13 spicy margarita. And I was like, okay, cost analysis, $13 is like, for a margarita, sure, whatever. But this other Mexican place that was in my old neighborhood, the margaritas were cheaper. So I was feeling a little bit miffed. Girl, they brought out what looked like a martini glass. That was full. Then they brought an entire separate shaker of the same margarita for $13.
God bless this establishment.
God bless this establishment.
Beautiful.
And I was like, oh, I'm so concerned for this establishment's liquor license. But I was like, okay. So I drink my full glass and then I fill it another time, like once. And pretty much the shaker is still entirely full from that. And I was like, if I were to drink that entire shaker, I would be off my ass. So I felt kind of bad and I didn't want them to think I didn't like it. It was good. I'm like settling the tab and he was like, do you want to take that to go? And I was like, you can do that. And he was like, well, it's yours. You paid for it. And so it gets sent with me in this little bag. And it's sealed with this little sticker.
My fucking God.
So I have the bag and that is what I'm drinking tonight is glass one of my margarita bag. Dude,
that's a lot of liquid.
Dude, the bag is still full. The bag is still downstairs in my refrigerator.
Are you serious?
And yes, it is the best $13 I have ever spent in my life. So when you come visit, I will
It's like never ending.
It's margarita, like free for all for $13. So yeah, come visit.
That was at least 4 drinks, no? 5?
It's probably like 6. Like, I'm going to be so honest with you. It's probably like 5 or 6 margaritas for like $13. Yeah.
What a deal.
What a steal. What about you? What are you drinking?
I have a little Titan apricot cider on cue here for my next drink after I finish my signature Truly lemonade, of course. Unfortunately, I ran out of all the strawberry ones, but hey,
it wouldn't be drinks with Defenders if you weren't drinking it Truly.
I mean, fuck, dude. I've actually been like, to be totally honest, like I've been feeling like um, kind of like burnt out a little bit these past couple weeks. I
Oh,
think
why?
just like doing all of these trials and just like, I don't know. I guess I just have like a meter, right? Of like
Mhm.
tolerance for my job and ability to like do it. And yeah, I don't know. I think that just like expending so much energy with like trials and stuff, it's like, I don't know. I get to capacity, you
Yeah,
know?
I
I
do.
don't know. I guess I'm still just learning how to figure it out. But I'm really glad that I work for myself and I can have this autonomy. Like when I really feel like I just cannot deal with talking to people right now, I can like, not be forced to deal with it right at the moment. But yeah, at the same time, I guess it's kind of a trade-off, right? Like if you're
Yeah.
always going to trial, like your calendar prep is gonna suffer. Or if you're just always doing calendar prep, like you're probably not going to make an effort to be trying to go to trial. So it's just a balance.
I have
I'm
said
sure you've run into
multiple
that.
Yeah, I mean, I've said to you multiple times that I feel like kind of the difficulty and I think some of the intrigue, at least I feel, to criminal defense is that it's so dimensional. You have to be a really dimensional attorney, right? Like I felt drawn to the fact that I'm not just a one trick pony in terms of, every day on the job is different. Every case is demands something different. And you really have to be a dimensional person, I think, to be a good criminal defense attorney. But it is hard when you're juggling so many plates and there are some plates that are heavier than others and you have to focus more time on that plate because it sometimes means that other plates get dropped and limiting the amount of things shattering in terms of your other cases, your personal life, whatever it is, the plate that kind of gets less attention, limiting the damage that happens when that plate drops inevitably and shatters is the hard part about this job. And I think kind of my frustration with people who don't understand how demanding this work is realizing the amount of juggling that I'm constantly doing as a person and people not having like patience with me, whether it be my clients, whether it be people in my personal life, colleagues, whatever it is.
Totally.
It's like, hey, the amount of like the shit show that I am orchestrating here is not easy. And so, trial demands a lot emotionally. It demands a lot of prep in different ways than, other types of hearings, but that's really real. Like I think that preparing for trial and the emotional labor that it is to go through trial is exhausting. And you've been to a lot in the last few months. So, I can only imagine how tired you must be because it's demanding. And
Yeah, I'm
yeah,
tired. I
yeah,
am tired.
that's super fair. So,
I think, yeah, dude, I think I told you before, it's like I can only do like two out of three things, right? Like be stressed and do my work, but I can't be nice or be stressed and nice. But you know what I mean? Like,
right.
so it's hard because I just feel so guilty when I feel like I'm shorter with my clients, like, than I should be. You know what I mean? Like, if I'm not super stressed, I can be more indulgent and kind of, baby people a little bit when they need it. But when I'm super stressed, I'm just like, okay, man, that's not relevant. Let's get to the point. Like, we got to get, you know what I mean? And
Yeah,
I feel so like such a shitty person. But it's
right.
like,
It's
we're just
hard.
humans and it's like, we got to get this shit done. And it's hard.
Yeah. It's hard when our time is like the world doesn't operate on our time, but we only have so much time to give to something because we have our own clock that we're having to work with. That's incredibly difficult. But I mean, yeah, you've had a lot of trial lately. It seems like you've had a lot of trial success, but even when you have good days in court, it's still exhausting. Just because you had a good outcome, that doesn't deplete or replenish the energy you had to put towards it. So, yeah, I'm sorry.
And it's such a trip. It's okay, man. It's just such a trip how it's like the wins, like those good feelings just like go away so quickly.
Hmm.
Like when I had lost my trial, I was so fucking devastated and pissed off for like 2 weeks.
Yeah,
And like my wins, I'm just like, oh, well, you were just lucky. You're still a piece of shit. You know what I mean?
it's so funny because I feel like a personality trait that I really love in other defense attorneys is I don't think criminal defense attorneys, or at least the ones I'm friends with, love winning, but I think we all fucking hate losing. And we
Yeah,
lose a
dude.
lot. We lose a lot. And our clients are constantly losing, a lot. And the stack, and we've talked about it before, the stakes that we feel. But I don't particularly think I enjoy winning as a lawyer. That's not, I think I'm kind of, if I were to be honest with myself, kind of motivated by this more negative. I hate losing. And that's kind of like a fire that I feel to like show up and do the job every single day. But to your point, I feel like when I've had things that I've won, I don't feel like that has emotionally inspired me or taken a toll or had any sort of effect in the way that losing has. Like I don't feel good when I win in court per se, So
It sucks. It's not fair.
it's
Like, I
not
wish
fair.
those good feelings would be just as intense as the bad feelings. Like, this
They're
has to
not.
balance out, right? But it doesn't. At
I
least
think
for
that's
me emotionally.
it doesn't for me either. And I think that that's such an interesting thing to think about because well, I'm just going to kind of pivot and I'm going to talk about kind of get into what we're talking about tonight,
No,
but just kind
please.
of pivot to my life too. I feel like, I was thinking about, you know, what I wish people would understand with our job. Because I think so much of what we've wanted to do in this space is talk about this work, right? And kind of just demystify it, break it down, talk about things that are interesting. But I was talking to other colleagues of mine and kind of just taking in legal news as it's coming. And it was kind of like, so much of our job, we are painted as the bad guys. And people think that we should lose because we're the bad guys. And so to your point of like, oh, like getting mad about loss, it's like I feel really strong in my convictions when I'm arguing for something. So then when I lose and then I'm made to feel like I'm wrong, like I take that really personally. But sometimes on the flip side, when there's wins in criminal court from the defense perspective, that's also painted in such a harsh light that is also really hard to digest in the world that we live in. Where if there's a big like defense win in the news, those defense attorneys are the bad guys, and that loss is a disgrace or something. And juggling that with then how we are in the world of just like competing interests, it's hard. And so um I'm just going to kind of get into it and we can kind of catch up, I think, as we
Yeah,
go. But
please.
I think that something that has been really difficult for me to kind of grapple with in terms of my career really is cases in which if I have, as a defense attorney, we are painted as monsters if we stand up for people who are accused of doing really egregious crime, right? We are painted as bad guys for that role because we're defending them. And I think we've kind of talked about, humanizing our clients and, our personal belief that even people who are accused of doing something horrible or have done something horrible still deserve a defense.
Yeah.
Um, but then we've talked about it, I think, briefly on here too, squaring that with being a woman, being some other type of, marginalized community or whatever it may be. And so I think that kind of existing in a world where there's just so much legal news going on about all sorts of stuff, how I react to headlines is very different than I think maybe people expect me to. And that's something I find kind of interesting. Like the people when news comes up that I feel like I can talk to about political in nature news are other people who are defense attorneys because they probably have the same like weighing. And I think that's something we've always kind of
Totally
enjoyed debriefing the news together about. So turning specifically to, the Weinstein news of, what came out of the Court of Appeals, it's hard like opening social media and then just seeing, how the news outlets are talking about it, where I feel bad saying it. Of course, my mind goes to, okay, why was it overturned? What's going on legally instead of what's happening from this culture perspective of the way I think other people are just kind of reacting to it. Um,
totally.
Yeah, and that makes me and I'm gonna be honest, like, part of that I grapple with, I'm like, "Oh, am I, like, a sick and twisted person that, like, my
Me
perception of
too.
that is different?" Um, and part of me is like, "Okay, if, you know," I'm just gonna walk you through my thought process. Part of me was
Please.
like, "Okay, if it was overturned, there has to be a reason. Let's find that reason." And then, while this may be somebody who was, you know, convicted ultimately of an offense, um, and has multiple cases similar in nature,
Yeah,
um, something went wrong, and that part intrigued my defense attorney brain. And I think that
definitely.
fundamentally, to the point of like where I feel like something is just neurologically different with me compared to like I think other people where it's like, oh, I hate losing. Oh, I absorb the law and headlines differently. And I don't know. I feel like that's kind of an isolating feeling.
It is, especially as a woman, again, because I mean, I know you, I've
Yeah,
known you for years. And when I think of like someone who advocates for women and like would be passionate about women's rights and women's issues, like it's you. You know what I
same.
mean? And there are certainly like aspects of our job that like are kind of that on the surface, I guess, seem like antithetical to that. Is that
Mhm.
the right word? Like in opposition?
Yeah,
Like when you have to cross examine victims or like, I, I mean, yeah, I don't know. There's some parts of it that I have a hard time with. I'm thankful that like I'm just practicing in misdemeanor court primarily right now, so I don't have to deal with like I mean like at my one of my old firms, my boss would have like felony cases too that I would help her with sometimes and it's just it makes you yeah, I guess feel maybe like a little bit twisted, I guess, when it's like, you have to like look at these cases where people have been accused of doing really fucked up things. And maybe the victim is like a little girl, or you know what I mean? Like a very vulnerable member of our community. And you have to like dissect the case and think about like, well, how could I cast doubt on her story or her
yeah,
credibility, And like I found that when I was like this specific thing I'm thinking right now, like I'm thinking about like I was going through the discovery and I found like this one thing and I'm like, I got that little like lawyer dopamine hit, when you
mhm,
find something good and you're like, oh yeah, fuck yeah. But then it's like I just took a step back and it was like, but like, what are you doing though? You know what I mean? I
yeah.
don't know. It's
I think
hard sometimes, like being a lawyer and being a person.
Yeah, and I think breaking down what you said, like, I agree. I think if I were to think of somebody who is, like, such a, you know, multifaceted person, such a multifaceted person
Sorry.
who, like, is such a cheerleader for, all people and women and not in a, like, I'm just gonna say, like, not in a, neoliberal feminist way, but in a very, like, dynamic feminist way. I think of you, but it's hard when you then, juxtapose that with what the job demands. And also then, the job and my brain in terms of like that part of my ideology, those sometimes just don't line up. And so to your point about like this dopamine rush, yeah, I mean, I have tried domestic battery cases as a lawyer, and from a defense perspective, had success in them. And I stand by the work that I've done, but it is also very difficult when your job has this aspect that can be challenging. And I don't feel right in sharing some of that because I don't want people to misinterpret what I'm saying. And so I'm trying to say my thoughts on here as eloquently as possible while also just being off the cuff because this is my fucking podcast. But at the same time, like, I want to be honest and transparent, and it's hard. So yeah, to your point, Kayla, when you go through discovery and, you're like, oh, okay, this is something that I think sheds some question as to whether or not this happened or whether or not this person's credible or anything like that. You get this lawyer rush as a defense attorney, but then sometimes you're like, oh, yikes, or like, oh, if I press that, am I going to be viewed as this bitch that's like that hates women or something like that? And so
Totally.
that's hard. So yeah, kind of, transitioning out of that, like back to the headline, I was looking into it because it came across my Instagram. That's how I found out about this news. I saw it on the New York Times, I think, on my Instagram feed. And I was like, okay. And then, in the days that followed, I saw kind of a different reactions to the conviction or the decision being overturned. Since then, I've just kind of, when I've had time, tried to look at what's going on. But I mean, something to keep in mind and, um, think about with Harvey Weinstein is that he has multiple cases going on, right? And so in this particular instance, we're only talking about the New York case, and the New York Court of Appeals ruled in a 4-3 decision. The majority said it was an abuse of judicial discretion for the judge to allow testimony from other women about his behavior, which I'm assuming in the post-conviction case, his lawyers were arguing that was an evidentiary issue and that evidence should have been precluded from trial. And
Totally.
Go ahead.
Oh, well, I was just going to say that's like one of the kind of like our theme today was talking about like victims' rights, right? Like thinking about how we think about victims' rights and how it like impacts our jobs. And like the rules of evidence are certainly like one potential limitation on a victim's ability to participate in the judicial process. And like exactly like you were saying, I have this quote here from the majority judge, Jenny Riviera. She wrote in part in the ruling, quote, "We conclude that the trial court erroneously admitted testimony of uncharged, alleged prior sexual acts against persons other than the complainants of the underlying crimes because testimony served no material non-propensity purpose. The only evidence against the defendant was the complainant's testimony and the result of the court's rulings, which was to bolster their credibility and diminish the defendant's character before the jury." So that's like what 403B land?
404B, yeah. 404B, because 403
yeah.
is relevance. Yeah, so it's 404B land, so it's improper character evidence.
Well, also irrelevant, more prejudicial, right? Than relevant.
Right. And they were saying it served no material purpose. So I'm curious, and the thing that I would be interested to know, and I was trying to find it, and I'm assuming that perhaps not, maybe it's me too in the weeds too much, but the other testimony that came in from, corroborating character witnesses, the amount of disclosure of that prior, like through the discovery process, I think would be interesting. I would also be really interested to know about the defense's motions in limine regarding such testimony prior to trial. And if they then said that the judge improperly ruled on the motions in limine, and then if they re-raised them in trial, it's just very interesting. But yeah, I just, to the point about victims' rights too, like, the point that you just made, I think was really interesting, where it's just because someone has perpetrated a crime against you in the past, you don't just get to come into court every single time that person has done anything ever else again and talk about what that person has done to you. In the most boiled down version of that, right? Just because somebody has done something, you don't get to come in and talk about what they've done the next time they're in court. And that might feel
And
harsh to
presumably, like
some.
these women who were testifying, yeah. I mean, they probably, I mean, I think that I read that there was something like over 100 women who like publicly made allegations against him.
Right.
So, I mean, we know he was what, convicted of how many counts was it in California? Um,
His California case is bad. Yeah.
let's see, he was sentenced to 16 years for rape and sexual assault. And then he was sentenced to 23 years in this New York case. Um, but anyway, presumably, like some of these women who testified, like, maybe didn't have their day in court. And then again, that's like another defense attorney thing where you're like, well, if they're unproven allegations, is that, yeah, it's definitely a complicated issue. I mean, we could kind of like, I don't know, discuss the rules of evidence here a little bit. Like basically, you're not supposed to be allowed to introduce evidence of somebody's prior bad acts to show that they have a propensity for committing that act, right? Like, okay, because he did this last time, he's more likely to have done it this time. They would have had to have like some other reason to admit that, right? And these were what? Bad character witnesses? I wonder
Right.
if
So
Weinstein testified.
that's something I don't know about the initial trial as well. And I feel like a bad legal mind for not knowing enough about the underlying case. But yeah, I mean, to your point, Kayla, you're not really allowed to just talk about somebody's bad character because it would paint them as, a criminal in the eyes of the jury prior to being able to find that they actually committed the crime that they're being charged with. So you have to have some other purpose for introducing that evidence, such as, motive, opportunity, intent, those type of things. And 404B stuff, at least in my experience, I think some of the most dragged out issues I've had with cases, especially cases that have gone to trial, is trying to limit some of the 404B stuff. I mean, I throw down when it comes to 404B stuff because, I've always said once the jury hears that bell can't be unrung. They hear that noise about something that your client has done, and their perception of that person is forever changed. Whether they would like to admit that or not, I think subconsciously we all are capable of thinking something differently about somebody once you've heard that they've done something bad. And that's kind of just the
Absolutely
sense behind it. But and then to the other point, there's victims in all sorts of crimes, not just crimes of particularly violent or sexual nature. Sometimes there's a car crash that then has criminal liability attached to it, and then there's victims
totally
that
like
are
a hit and run.
right, or a DUI perhaps, or something, or maybe a person drove off the road and hit a fence and that person's upset about their property damage. And those can be contentious as well. And, sometimes in my experience, people who are, victims of, in the case will come to all of the different court hearings. And so you're navigating that dynamic every time you go to court. And that's difficult because you don't
Do
want
you
to come
see that
across.
often?
I've had it a few times. It's not particularly common. I think the two things that I think of in terms of the two sides of the coin in cases where there's a victim, you have victims who really don't want to participate. And so again, back to that kind of legal
Majority of
mind.
victims.
Right. And so
At least in domestic violence cases.
right. And so you go kind of back to that criminal defense mind, which we talked about, kind of how you feel conflicted is like, okay, well, if the victim's not going to participate, are we really going to go to trial? And so that, you have that game that you're playing in terms of strategy. And then you have victims who are so upset that they come to every single court date and they try to speak at every single court date. And you have to like fight with the judge to try to make sure that they don't get to say anything because maybe your client hasn't pled or been convicted of anything yet. And, their statements could be made part of the record. So you're like, okay, what are we doing here?
It's a trip, man.
It's a trip. And you don't want to come across as, in some cases, I would say you don't want to come across as insensitive. But it is very hard to just like sometimes you just get to court and you're like, I'm just trying to do my job. Like, I am not trying
Yeah.
to fight with a person or dodge a person in a hallway. And sometimes you have to.
Have you had to cross-examine a victim on the stand?
So I have not. Um, I've had to be in trials where we have. Cross-examination just in general is I think when I was in law school, they were talking about how it's surgery and not slaughter, right?
Oh,
So you want to,
interesting. I've never heard that phrase.
yeah. So cross-examination, I've always viewed it as surgery and not slaughter, where you're asking very thoughtful, pointed questions, and and I think that I always have also heard the kind of the idiom of just like you don't want to ask one question too many in cross-examination. So you want to
like
be,
that.
yeah. So you want to just ask.
I think that's true.
Yeah. And
I
so
agree with that.
And so I've had to think about if I were to cross-examine certain people in certain cases. And I always get nervous that, especially if it's a victim, the amount of prep you have to do for every single question, while also giving yourself room to be, improvisational in their response makes me nervous. And so,
Girl, yeah. I'm
yeah,
mostly improv. I'm going to be honest with you.
right.
I would get stressed out if I had to prepare too much. And I feel like especially from the defense side, it feels very reactive.
Yeah.
It's like, at least for me in the few trials that I've had recently, I felt like a lot of the battle was like on the front end, just trying to like keep out certain evidence and then just like making appropriate objections and, you know what I mean? Going for reasonable doubt. I mean, I'm sure that if you were trying to like build a whole defense and introduce your own witnesses and stuff, that would be like a whole nother monster.
I think that you and I are also very different attorneys in terms of just who we are as people, which is something that I think is so beautiful about litigation in general. I think there's no good, like one way to be a good litigator, and different people who are good litigators all have their own different kind of flavor. But I would say you're much more natural in how you just are with your work. Whereas I am not. I am not. I think the more experienced I get, the more I can just kind of be, kind
You'll
of
find winging it gets a lot easier the longer you do it.
right. And I'm just not somebody, especially with trial, I am so not comfortable winging it. Because I am worried about my golden rule of I don't want to ask one question too many. So I want to be very, I have a list of certain things I want to get in from cross exam. How I word those questions, I think becomes very kind of, that's where some of the natural kind of flow goes. But it's not easy. And for people that it is easy, there's lawyers who it's very obvious that it's easy and kind of natural for them. I think you fall into that category. I think that I'm very much.
You're sweet.
Yeah.
Not everything's easy for me. A lot of things that are hard for me are easy for you. I think I'm just kind of good at thinking on my feet, but like talking to people and like being annoyed, I am not good at that.
But yeah, I mean, I think that there's other things that, back to victims' rights a little bit where, there's kind of that tension internally. So, say you have, I mean, for all sorts of reasons, you resolve a case, right? So in this hypothetical, you've resolved your case and there was a victim in the case and now you're at sentencing. Well, victims by law have to be notified of the sentencing prior to the person being able to be sentenced.
Do you have a victims' rights statute in Idaho?
I believe so. So I believe so. It comes up every single sentencing when there's a.
Yeah, dude, I hear it's like that too, but I've never actually read our victims' rights law. So I'm like kind of wanting to pull it up, but that sounds right. Like they probably have to be notified of like how the prosecutor, because I know like the judge will regularly ask the prosecutor, especially when we're like resolving some kind of a domestic violence case, if they've notified the victim or like
I
tried to
found the
get a hold of the
statute.
victim.
I found the statute.
I'm
I
so
think,
curious.
yeah, so it's in criminal procedure, but it says that, so there's rights of the victim during investigation, prosecution, and disposition of a crime. Yeah, it's a pretty long
Interesting.
statute, but we all of our judges will not go forward with sentencing unless they can confirm from the prosecutor that the victim has been notified of the hearing, because they
Or
have
that
a right
they've made reasonable efforts.
that they have tried to notify. Yes.
Okay, yeah.
Like in the same way of like receiving, like court notice, right? In that they have made effort to give notice. Um, and sometimes that's hard because it's, court and cases are fluid. I think, especially in the like public defense sector, because sometimes people are held on multiple cases. And so you're resolving one while they're maybe having a hold in another case from a different county. And so if you have this case that you resolved that maybe has a named victim, you're just trying to get your client's matter resolved and so they can move forward. And if, maybe the prosecutor has dropped the ball a little bit and not notifying the victim, or you're wanting to do change of plea and sentencing in that same hearing, you probably can't get your case wrapped up quickly.
That's fucking annoying.
And it's annoying. And I feel bad every single time that I get pissed because I'm like, okay, we came to court and we can't handle it. Like we can't just get this over with, especially if we're resolved. That I think is my biggest pet peeve. And I feel kind of bad about it because I understand.
You shouldn't feel bad about it.
But I get kind of pissed. I'm like,
but I mean,
really?
It's the prosecutor's job to do that. Yeah. And it's like, it's not like easy to have a crime hanging over your head, right? Like our clients, I mean, maybe there's a no contact order in place and it's like they can't go home until this crime is resolved. And then they're like mad at, you know what I mean? It's like, yeah, it really sucks when you're like ready to resolve a case and you have all of these fucking cases and it's like you can finally resolve one. And then, yeah, the state drops the ball and you can't.
Right. And I'm just like,
it's the worst.
I'm like, we all had to get notice of the hearing. Why didn't you just pass it on? Like, holy shit. I feel bad for getting annoyed, but it's happened a couple times to me where we've had to, and maybe, in reflecting upon my own work, maybe it's that I didn't fully communicate with the prosecutor that we were like wanting to go to sentencing that day. But you know how cases go. Sometimes you resolve it like 5 minutes. Right. But sometimes we resolve the case like 5 minutes before the hearing. And just the nature of the work.
That's the name of the game.
Right. I mean, the amount of cases you resolve in a hallway at a courthouse is, I mean, a lot of them, right?
Man.
Yeah.
Yeah, dude. It's really interesting. Do you interview alleged victims often, or does your office have like investigators that do that for you?
So I try not to have direct contact with victims like off the bat. I just don't think it's best practice. So technically, usually I will get like an investigator to be involved. And something that I also think is interesting, Kayla, and I'm assuming that it's in your standard discovery request, and I don't know Washington statute or criminal rule, but in Idaho, our criminal rule for discovery has, a subsection where the prosecution is supposed to turn over statements that any of the state witnesses have made to the prosecutor or any agency of the prosecutor's office or any agent of the prosecutor's office, right? And it's a mandatory disclosure. And I feel like, and maybe this is just me being too dark with it, but I will go through a case and I'll get the police report and it'll say like, there's all these different witnesses and stuff. And then I'm thinking, okay, I'm working on my investigation and, sometimes trial prep and everything. And I think that the state can be, and maybe it's me speculating, but I don't feel like I get a lot of like supplemental discovery responses about statements that their witnesses have made. And it's like, you are
I've never
required.
once gotten that. And I think we have the same rule. I think we have a very similar rule because I've seen something similar before, but I've never once gotten that.
It's wild. And so
have you ever once gotten it?
I have, and it's because I've supplemented and asked for it afterwards again.
Like specifically?
Mm-hmm. Or I've been kind of snarky in email and be like, hey, by the way, you need to be giving me those communications. Thank you for letting me know that you talked to this person, but you need to tell me exactly what was said. So
that's not snarky, sis.
And I think that the funny thing why I'm tying this back to our discussion about victims' rights, I think that there's some dispute as to whether or not, and maybe I'm not sure if it's a dispute or if I'm confused about the actual, contours of the rule. But it seems as though
story of my life,
that rule might not be as stringent in terms of disclosure of victims' statements.
Why would it not be though?
And that's my thought, right? But then
they're the most important.
I would agree. So I think that that's something that I have found to be of particular interest in terms of how, because right, if it's a crime where there's a victim, it would seem that the victim statements are probably the most important, right?
Well, Idaho and Washington lawyers, like, holler at us, let us know.
Right.
This seems fucked
Isn't it interesting? I think it's interesting. I've debated that particular point before, and I think it's something that I don't really feel like I have full clarity on. But for what it's worth, with victims' rights, I'm not sure if you have to have. And I understand the other, the concern of just, what if you have a victim that's recanted? I would argue that that's exculpatory, but that's just me.
Oh, 100%.
And it's just interesting, right? So something for you to circle back with me on, because it's something that I've thought about it before. So, and I'm not sure if you would get any pushback, or if you're going to start including. And I think there's some strategy to not specifically asking for them to supplement, that they've talked to the conversations that the prosecutor is supposed to give you. I think there's some strategy maybe to not asking for it. But if you're made aware or you have a thought that the prosecutor has talked to the witness, theoretically, you're supposed to be given the information on it. And so I'm just curious as to your practice, if it was something that you would specifically ask for, if you view witnesses as victims as kind of separate from regular witnesses. Seems like you think they're more important. I agree, but it's just food for thought.
Yeah. I mean, and it's interesting too, like working for a firm that has like investigators and support staff and stuff. It's like, it's great that you don't have to like deal with this bullshit hands-on usually. But yeah, unfortunately, I kind of do. Sometimes I try to just keep it like really quick and really like, just to the point. Like, hey, I'm so-and-so. I represent so-and-so. You don't have to talk to me if you're not comfortable. We can arrange to have the prosecutor present. I'm just wanting to know how you feel about this case and what do you want to see happen. And usually they're like, I want it dropped. I don't want to participate. And I'm like, okay, cool. Have a good day.
And then what do you do from there?
And then I will, it depends like what my client wants, if maybe I talk to my client and they're like, okay, cool, well, fuck it. Let's just try to go to trial because maybe, homeboy won't show up. And then, how are they going to prove it without him? Or maybe they want like to do like a diversion type thing, and so I'll go to the prosecutor and be like, hey, I don't think the victim really wants to participate. This is a weak case, blah, blah, blah. Let's wheel and deal.
Okay. I find it frustration.
Yeah, it's interesting.
Yeah, I find it frustrating. And again, maybe it's me being just different in the head. But I get kind of frustrated when, and I'm going to be the bad guy for 5 seconds. I'm going to be the bad guy for 5 seconds.
Stop.
I think I am. When, I think that so much of the way the state portrays themselves is that they are these advocates for victims, right? And sometimes there's cases where victims don't want to participate, but the state then still proceeds on prosecution.
And they scare them into coming to trial when they don't fucking come because they're scared. I think that's what happens. Dude, that's such a good point though, Addie. Like, seriously, they really do act like they are just like for the victims, but then they're like, well, fuck the victims if it's going to get me a conviction.
Or just like, we're for people on our terms. And
Exactly.
I don't know. Like, it's also, we're put in this position that is so interesting. And I think the role of a criminal defense attorney is so many different hats, because it's not just, our job is not just going to trial and getting our clients off like so many people think it is. And sometimes our clients want that, but sometimes our clients want very different things. And I think that the state should have, to the extent, not to cast my opinions on a job that I've never done, but I would think that their position on, and to some extent, I think that some prosecutors in my experience have been this way. So I'm not, just doing a blanket statement, but I think to some extent, their position towards victims should be somewhat similar. That it's like, hey, what do you want to have happen here? And I think that should be the controlling force behind their position on a case. And
I wish.
Yeah.
I wish.
Me too.
I literally just had a case where I had a victim literally go up on the stand, and like the first thing he does is like try to plead the fifth. Because he didn't want to be there. And presumably the prosecutor, scared him. And they're like, you can't just plead the fifth.
The Fifth Amendment doesn't the Fifth Amendment doesn't apply to you at the moment.
Like God bless you, kid, but unfortunately that one's not going to work today. But yeah, that kind of shit pisses me off. It's like, what are we doing here? And I'm sure if we were to add them, they would say maintaining order, keeping the community safe. Dude, I was like, I had this prosecutor who was like seriously considering trying to hold somebody in contempt, like an alleged victim, for not coming to court. And I was telling her how that's like not good policy because that discourages people from calling the police. And she was saying that, maybe people shouldn't be calling the police, like if they don't want to be coming to court. And I'm like, well, people call the police for all kinds of reasons. And you also have to remember that especially like domestic violence victims, like, I did the domestic violence clinic in law school. And the one thing that like I will just never forget and has just always stuck with me is like those victims are the experts on how to keep themselves safe.
Yeah.
If they don't show up to your appointment, if they don't take your calls, like just trust that they're doing whatever the fuck they have to do to keep themselves safe. Right. And I think that prosecutors need to like take that into consideration. Like people, they're not just trying to like fuck with you. They're not just trying to like make your life harder. It's like they have their own considerations, and some of them are, maybe safety considerations.
Right. And I understand that, the circumstances are much more nuanced than just the positions that we're just kind of generalizing, right? But I think that I think that people who are in cases where there's a victim that, to the extent a victim exists, and both sides, there's victims who really want to go to court and really want their day in court. And I think that when prosecutors have those types of individuals in a case, that oftentimes does shape their position on what to do with that case, because they won't give out a plea deal or anything like that, depending upon what the victim's position is. And I think the flip side could be really hard. Maybe they have a really, headstrong victim and maybe not the strongest case. And I don't know what they do in that situation, right? That's difficult. But
that's a good point. That is difficult.
That's difficult. And I think that to your point, I always think about person to person, like person crimes or crimes against people when I think about kind of the difficult dynamics, because I think DB is really kind of the outlier in terms of a lot of considerations that some cases just don't have. And, you know, there's a lot of statistics about domestic violence victims not wanting there to be a criminal and all of their different reasons as to why. Um, but yeah, I think that just generally, you know, it's hard the role that victims' rights play in the considerations of a case. And I'm not saying that I have a clear answer as to what that should be, but I think in terms of back to the Weinstein example, like, you know, you want to give it's just it's hard, I think, for both sides. And it really, there's rules around it. And a lot of people, I think, struggle with those rules. I think a lot of people struggle with the case being overturned because I think the rule that it turned on apparently shouldn't exist. And who knows what's going to happen from that case from there. I think that the prosecutor indicated that the prosecutor wants to retry the case because I think it got remanded.
Oh, yeah. Yeah,
and
they
so
already said they were going to do it.
Right. So it'll be
And that's, I
interesting
think,
to
the
see.
same DA who's prosecuting Trump. The Manhattan DA. Yeah.
Interesting.
Homeboy's got his hands full.
Heavy is the
Or
head
homegirl.
that is
I should.
Heavy is the head that is the Manhattan DA.
Goddamn. I bet he drinks a strong Manhattan.
I hope he does, or she does, because
yeah, we should assume she.
Aren't we all?
Oh, it's tough. Yeah,
Well.
Seriously. Amen, sister. Well, on that note, you guys, like, it's tough out here. We're doing our best. Like, obviously, we are criminal defense attorneys, so our perspective is biased, right, to the shit that we have to deal with all the time.
Yeah.
But we certainly know that there are good prosecutors out there, and we respect the work that they do. But yeah, it's challenging.
And I'm not saying
so
that
on that, please.
Oh, I was just gonna say, and I'm not saying that, you know, obviously our take is not should be taken with a shot, right? I mean, our perception on the situation, our perspective on the situation is not for everybody, and that's okay too. So,
yeah, sorry if we upset you guys. Hopefully next time will be less upsetting, but I don't know, because I think we're going to talk about Kyle Rittenhouse and trial strategy.
From one dumpster fire into the next. And
let's go.
That's what we do on Drinks with Defenders. Have a good one and cheers.
Cheers.
Cheers.